Page 6, docket number 19618.
All right. Mr. Oliver, you're here to be arraigned on the charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, we'll appoint the public defender, and they're represented here by Mr. Winston Vaughn. And Mr. Vaughn, do you wish a formal reading of that?
No, Judge will waive that in a plea not guilty.
The plea of not guilty is entered. When do you want to set this?
Can we do?
We'll put it on November the 18th, and if it
Okay,
needs to be
that's
put
it.
off, we can put it off. We're going to set you for next week on November the 18th for hearing if it can be heard on that day. If there's some reason it needs to be postponed, we'll give you another date.
Thank you, sir.
Your Honor, I have Messiah Israel on page 4 of the docket. Mr. Israel's here in the courtroom in the back. We're here to get a date.
All right, so you need a date.
Yes, Your Honor.
And this is a stalking charge, is that right?
It is. There's two of them. Two charges.
Well, violation of the order of protection and restraining order and stalking. All right. You want it tried this month?
Sure. I don't think Miss Sylvie would be appreciative of that, or General Sylvie, but
So if you're gonna set it, you're gonna have to set it in March, is that correct?
yes,
Your
Your Honor.
Honor, I'm standing in for General Sylvia today, and from her notes, she has March 24th and 25th specified with her Cheatham County Court.
March 20, let's just do March 25th.
25th.
Right.
Thank you, Your Honor.
And this is Israel, is that correct?
It is, Your Honor. Thank you, Your Honor.
All right. All right, at the jail, if you'll unmute, please.
Your Honor, this is
Okay.
Kelly Reed, page 7 and 8, docket number 19426.
All right. Public defender, you represent Mr. Reed.
Yes, this is Mr. Richter's case. Is it a amended VOP or?
This is an arraignment on an unlawful exposure. No, I'm sorry, that's a different case. This is Kelly Reed, so it's a probation violation, and it's an amended violation of probation arraignment. So,
Okay. Yeah, we put this on. The December docket for it. We'll wait formal reading or plea not guilty.
plea of not guilty is entered. When do you want to set this one?
December, please. December,
December?
is there a VOP date in?
16th is what I have,
Got it.
or the 16th of December is what I have.
December 16th. All right. Your case is set for December 16th to allow Mr. Vaughn to have an opportunity to get ready for your hearing. Thank you.
Good morning, Your Honor. Justin Paul, on behalf of my client's name is Richard Birdwell. I represent the Dismiss House, which is a treatment and reentry program. I was just informed this morning that he moved out a couple of weeks ago. I tried to get in contact with him and have not heard from him. So we will be withdrawing that motion to waive costs.
So on Richard Birdwell, the reason it's here was an appeal from the ruling in general sessions, and it was to appeal the cost. Is that right?
Yes, Your Honor, that's
And you're
correct.
striking your notice of appeal then.
That's correct, Your Honor.
The appeal is dismissed on your motion. Thank you.
Thank you.
All right, at the jail.
Your Honor, this is Joshua Widener, page 8, docket number 18322.
All right, Mr. Widener, you're here to be arraigned on a charge of violation of community corrections. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
We'll appoint the public defender who's here in the courtroom, Mr. Winston Vaughn. Mr. Vaughn,
We'll wait formal reading or plea not guilty, Judge.
plea of not guilty is entered, and when do you want to set it?
We can probably do this one next week, that it looks like.
All right, we're going to set you for hearing on November the 18th. If Mr. Vaughn needs more time, then we'll give you another date. But right now, you're set for November the 18th.
Okay, thank you, Your Honor.
Thank you. I'm taking up whoever walks up to the podium. So.
I have a plea for you, Judge, Mr. Chauncey Spence, and he is in the courtroom. I'm not
What was the name?
Spence, Spence. Sorry, Judge, I don't know the docket number.
That's all right.
I'm sorry, the page number.
8. All right, I've been handed a document indicating that Mr. Spence is going to be entering a plea of no contest to count 3, possession with intent to sell a Schedule II drug, Class B felony, and he would receive a sentence of 8 years in the Tennessee Department of Corrections, suspended to supervised probation. He would be ordered to pay court costs and the mandatory fine, which is $2,500. Is that correct?
I was unsure, Judge. I didn't know if it was 2,000 or 3,000. And I'm trying to get clarification on that.
Mr. Willoughby is back there.
Put your hands up, everybody.
Do you know what what is the minimum?
It's 2,000.
How much?
I said, I think it's 2,000.
2,000. All right.
Thank you, Judge.
We'll put that in there. The remaining counts will be dismissed. So Mr. Spence, raise your right hand. Let's place you under oath.
Yes.
Thank you. You can put your hand down. Now state your full name for the record.
Chauncey Spence.
Mr. Spence, you're here today on an indictment charging with a sale of possession with intent to sell of a controlled substance, and there was a multi-count indictment. It's been indicated you're going to enter a plea of no contest to 1 count, and the rest would be dismissed. But do you understand that no contest plea means that you are not saying you did anything wrong? You're not going to admit anything, but you're not going to contest the state's evidence, and then they're going to tell me what their evidence would be at trial, and that evidence will be used by me to find you guilty according to this agreement. Do you understand that?
Yes, y'all.
Have you seen or been shown a copy of those charges against you and talked it over with your lawyer, and you and Ms. Stevens have an opportunity to discuss the range of punishment you're facing as well as any possible defenses you might have? You feel like you understand what you're charged with? All right. Do you understand that you would have the right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
You understand that if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that if you went to trial, you and Ms. Stevens could if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of any crime?
Yes, sir.
Do you understand that if you went to trial, you and Ms. Stevens could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify in your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that if you plead guilty or no contest, rather, you're waiving your right to a trial and to an appeal, and all I will do is approve what your lawyers worked out?
Yes, sir.
But do you understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Yes, sir.
You understand everything I've explained to you?
Yes.
Do you want to waive your right to a trial and to an appeal by entering a plea of no contest?
Yes, sir.
Then is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this
No,
against
sir.
your will? You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges.
Yes, sir.
And I want you to listen as Mr. Willoughby tells me what the state's evidence would be if this case went to trial.
Yes, sir.
Yes, Your Honor, 19746 on January 9th, 2025. Agent Kent with the, Cheatham County Sheriff's Office was traveling on Highway 12 past a white Mercedes. He had knowledge that Mr. Spence did not have a valid driver's license. Conducted a traffic stop. During the traffic stop, there was an odor of marijuana coming from the vehicle. They did search the vehicle as well as Mr. Spence's person. They found a large sum of money in his pockets. I believe it's around $1,400. And they explained to him that if they took him to jail and he had drugs on him in the jail, that would be a felony at that point in time. He handed over what turned out to be 4.5 grams of what he claimed to be heroin.
I'm not asking that you agree with the state's evidence, but you understand that's what they would prove at trial.
Yes, sir.
You still wish to enter this plea according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Ms. Stevens has done a good job of representing you competently?
Yes.
Ms. Stevens, you know of any reason he should not enter this plea?
No, Judge.
Then Chauncey Spence in docket number, on docket number 2025 CR 19746, upon your plea of no contest to count 3, the remaining counts are dismissed as a part of the agreement. I find you guilty, sentence you to 8 years in the Tennessee Department of Corrections, and will be suspended to 8 years of supervised state probation. You're ordered to pay a $2,000 fine and court costs. You'll need to see the probation department before he leaves. Step around.
And Your Honor, I have two arraignments. I'm standing in for Mr. Bernie McAvoy for Carolyn Lee Williams.
All right, what's the first one?
The last name is Williams, Judge. Caroline. Oh, there's
Caroline Lee Williams in docket number 2025 CR 19781 show that Ms. Stevens is the attorney of record.
oh, no, Your Honor, Bernie McAvoy. I'm standing in
Sorry,
for, yes, Judge.
The boy.
Morning, Your Honor.
Good morning.
Judge, Mr. Lewis is charged with attempted second-degree murder, ag assault, and reckless endangerment. He's pleading open today and going to sentence in front of you, Judge, on the charge of ag assault. That's count 2, counts 1 and 3 are dismissed.
Thank you. All right, Mr. Lewis, raise your right hand. Let's place you on the road.
I do.
Thank you. You can put your, thank you. State your full name for the record, please.
My hearing isn't that great. I'm sorry, Your Honor.
All right, we're going to get you a hearing device to help you with that. I need you to state your full name for the record, please.
A lot of feedback.
That's okay.
All right.
You're good.
Yeah,
It's okay,
can you hear?
somewhat.
Well, I'll try to speak as loudly as I can.
That's
so-
good, Your Honor.
State your full name for the record.
Timothy Joseph Lewis.
All right, Mr. Lewis, you're here today on a multi-count indictment, one of which charges you with aggravated assault, reckless endangerment, and attempted second-degree murder. It's been indicated you want to enter a plea of no contest or nolo contendere to a single count of aggravated assault, and the other 2 charges would be dismissed. And you will be you will be pleading to the offense without an agreement as to the sentence, and then we'll have to conduct a sentencing hearing for me to determine what kind of sentence should be imposed. Do you understand that?
Yes, sir.
Do you understand what you're charged with, and have you and Mr. Vaughn had an opportunity to go over the indictment and the charges against you to let you understand what you're charged with, what the range of punishment is, and any possible defenses you might have?
Yes, sir.
Well, it's indicated you want to enter this plea of no contest. That simply means you understand the state's evidence. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence about your guilt or innocence on aggravated assault, and then we will go to sentencing. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to contest everything and to plead not guilty and have a speedy and public trial by jury?
Yes, sir.
Do you understand if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand that at trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with an appeal?
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to contest the issue of your guilt or innocence?
Yes, sir.
And you will then be convicted as a result of this agreement.
Yes, sir.
But the sentence will be at a sentencing hearing, and you will have the right to appeal whatever sentence I impose on you at that sentencing hearing. Do you understand that?
Yes, sir.
Do you understand everything I've explained to you thus far? And do you understand by entering this plea, you're waiving your right to contest your guilt or innocence on the attempted or on aggravated assault?
Yes, sir.
Do you understand that's going to result in a conviction? And that conviction is going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you? You need to speak up a little bit. We're recording everything that's being said, okay?
Okay, go ahead.
Do you understand everything I've said and I've explained to you?
Yes, sir.
Do you want to enter a plea of no contest to the charge of aggravated assault and go to sentencing?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you against your will to do this?
No, sir.
Do you understand I cannot accept this plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Sir.
Then I need you to listen as the state tells me what their facts would be if you went to trial. Mr. Willoughby, you may need to try to speak as loudly as you can into that microphone if it's.
In docket 19649 on July 26, 2024, officers were called out to a church here in Cheatham County where an individual had been shot. A further investigation revealed that Mr. Lewis and the victim in the case had been in a discussion at Mr. Lewis's house where the victim had some adjacent property. That conversation got heated over whether or not Mr. Lewis believed in God or not, and culminated in Mr. Lewis going in his garage, getting a handgun and shooting at the victim. He was hit in the leg. He did survive and comes by the office periodically and has some mental issues from age, but has no physical limitations really. The officers, when they went to Mr. Lewis's house, he took them through his version of events. The state would contend that there are some inconsistencies with the physical evidence about where the victim was in relation to Mr. Lewis and whether or not he was provocated to go retrieve his weapon. I have spoken to the victim's family. They are in agreement with this plea.
All right, Mr. Lewis, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, sir.
You still wish to plead according to this agreement?
Yes, sir.
Are you satisfied with your attorney services?
Yes, sir.
You feel like Mr. Vaughn has done a good job so far in representing you? Mr. Vaughn, do you know of any reason he should not enter this plea? Then anything further from the state, Mr. Willoughby?
No, Your Honor.
Then Timothy Lewis and docket number 19649, upon your plea of no contest to count 2 aggravated assault, I find you guilty. Order that you go to sentencing hearing in this case. As a condition, right now, you would have no contact with the victim in this case, pending that sentencing hearing. Counts 1 and 3 of this indictment are dismissed as a part of the agreement. We will order a pre-sentence report. Now we need to talk about when we're going to set this.
We asked Mr. Lewis, do you have an ankle monitor?
I'm sorry, sir?
Do you have an ankle monitor?
No.
Okay.
Not at all.
March is fine with me, Judge, as far as sentencing.
Are you, the state have any opposition to putting the sentencing hearing off till March?
If, I know Mr. Vaughn and I had talked about if Your Honor wanted to put it sooner. I don't know if the pre-sentence report could get done and maybe in Dixon County.
Well, next month is December. And then I'll be in January, I'm in Dixon County, so we could do it in January. I think that would be plenty of time if you want to do it in Dixon.
That's Judge Locker Bash's third one. Yeah, I mean.
You want?
So that's Judge Locker Bash's term month. I would vote for March.
Yes, me too. I changed my vote.
All right, sounds like the simplest thing is we put it on March. Do you want to put it on the March 10th at 1 o'clock?
Yeah.
Yes, Your Honor.
Well, we set some motions on the fifth, right?
And we
But
did
I'm
have-
thinking about that fifth date I gave you, I could do this on that same day, couldn't
Yes, sir.
I? All right, March the fifth.
Will they just get in contact with Mr. Lewis about the pre-sentence report?
Probation, we'll do an order, the probation should be in contact. They may have to go through you to find out how to reach him, so.
Fair.
All right, on Patrick John McClanahan.
There's paperwork down there. He's, doing a conditional plea.
All right, I've been handed a document indicating Mr. McClanahan is going to enter a plea under 4035-313, which is what we call a judicial diversion or post-trial diversion, to aggravated assault, was to be placed on probation for 3 years, to have no contact with the alleged victim. He would be ordered to pay a $4,000 restitution, and his GPS monitor would be coming off if deferred. Is that right? What about the monitor?
It will come off as a condition of this.
All right. Mr. McClanahan, raise your right hand. Let's place you under oath.
Yes,
State your full name for the record.
Patrick McClanahan.
Mr. McClanahan, you are here today on actually an indictment charging you with both aggravated assault, domestic assault, false imprisonment, and reckless endangerment. It's been indicated that because you have no prior criminal record, that the state has agreed to allow you to enter a conditional plea, which is basically where you would enter this plea and be placed on probation for a period of 3 years. If you comply with all of the conditions of your probation, then you would have the right at the end of that time to apply to have your record expunged. But if you violate your probation or you get arrested on some new charge, then this would become a permanent conviction on your record, and you would be required to serve a 3-year sentence or be brought back to be sentenced within the range to even more than 3 years. Do you understand that?
Yes,
Do you understand what you're charged with? And have you and Mr. Lockhart had a chance to talk over what the charges are, what your possible defenses might be, and your range of punishment you're facing?
yes,
Well, it's indicated you want to enter this plea of no contest. Do you understand you have a right to plead not guilty and have a speedy and public trial by jury on all these charges?
yes,
You understand that if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own.
yes,
Do you understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
yes,
You understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine all witnesses the state might call to testify, and you could bring in your own witnesses by using a subpoena.
yes,
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
yes,
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
yes,
You understand that if you enter this plea, you're waiving your right to that appeal and to the trial, and all I'm going to do is approve what your lawyers worked out.
yes,
You understand that what I've explained to you about being placed on probation and the requirements that you have to meet for that probation will determine whether or not you can have this record expunged,
yes,
whether or not you're successful on probation. Do you understand everything I've explained to you?
yes,
And you understand that if you violate your probation, not only would you have to serve the sentence imposed at a separate hearing, but you would also have a permanent conviction on your record that would make more severe the punishment you received if you're ever again convicted of a crime.
yes,
Is your decision to enter this plea according to this agreement?
yes,
Is your decision to plead no contest today voluntary?
yes,
Anybody forcing you to do this against your will?
no, sir.
Do you understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes,
Now, I want you to listen as the state tells me what their evidence would be if you went to trial.
Yeah.
General?
Your Honor, the case where you go to trial, the state would show that on February 14th, 2025, Valentine's Day this year, officers responded to the home of Janelle Williams located at Mosley Ferry Road. Ms. Janelle Williams had been involved in an altercation with the defendant. During the argument, the defendant broke multiple items that belonged to Ms. Williams, such as a phone, TV, and two slashed off-road Jeep tires. The defendant pulled Ms. Williams from the house by her arm. He then did display a gun while holding her on the ground and shot off a round, scaring the victim and placing her in fear.
I'm not asking that you agree with those facts, but do you understand that's the state's evidence they would use at trial?
Yes,
You still wish to enter a plea no contest according to this agreement?
yes,
Are you satisfied with your attorney's services?
yes,
Feel like Mr. Lockhart's done a good job of representing you competently?
yes.
Mr. Lockhart, do you know of any reason you should not enter this plea?
No, Your Honor, and I've also explained to him that, General Sylvia said if he does violate, he needs to understand it'll be 3 years at 100%.
You understand that?
Yes.
And that, as Mr. Lockhart says, that 3 years, but as I explained to you, under 4035-313, if you violate the terms of that probation, then you can be brought back and sentenced to more than the 3 years if you violate it. We're giving you 3 years probation. If you stay out of trouble and do what you're supposed to do and have no contact, then that will be the length of your probation.
Yes.
All right. I've signed a no contact order that you're to have no contact with Janelle Williams, period. All right. Thank you. He needs to see the probation department.
And, Your Honor, any idea when he could get something, that would allow him to get this monitor off his ankle?
Probation department can explain that to him, but I would assume that it could be done today, so.
Yes, Your Honor. Thank you.
Just have a seat over on the bench.